Hello and welcome to our Shriver Hangout for January 2016. My name is Amanda Moore and I'm the Director of Online Content and Communities at the Sargent Shriver National Center on Poverty Law. With me today I have 4 guests and we're going to talk about due process in a modernized public benefits system. And I'm excited to have them with me. I have 3 guests in New York and 1 in Philadelphia. So we'll start with Kristen Dama in Philadelphia. She's a supervising attorney at Community Legal Services of Philadelphia. Hi, Kristen.
Hi, thanks for having me.
I'm glad you're here. And we have 3 fine folks in New York City at the National Center for Law and Economic Justice. We have Mark Cohen, the Director of Litigation, Gina Mannix, a program director and senior attorney, and Greg Bass, a senior attorney at NCLEJ. Hi, guys.
Hi there.
Hi.
And thanks to all of you for tuning in today. We have had a huge response to this topic and to this event. We've had more than 450 of you register for it, which I think really speaks to how common this issue is, how widespread it is. We've had people register from 44 states and the District of Columbia, which probably means that these issues have come up in at least 45 different situations. And so we are going to do our best today to hit on some of the broad topics that you're facing. We would love to hear from you during this conversation. We'd like to have your questions, your comments, your anecdotes, and there are a few ways that you can send those to us. I will explain what those are now. So some of you are watching us through the Google Hangout itself. If you're doing that, you can send your questions to us through the Q&A box. So you can find that by hovering the mouse over the left side of your screen, and you'll see a blue box there that says Q&A. If you click that, you'll have a chat box open up down the right side of your screen, and you can send us questions there. Don't worry, we won't see your face. We won't hear you. It'll just be words that pop up for us to read. If you want to go ahead and try that out now, you're welcome to. You can just send us your name and where you're watching. We'd love to get those channels going. Now, I know not all of you are watching that way. Some of you are watching the live stream through the Shriver Center's YouTube channel. If you're doing that, we still want to hear from you. There are a couple ways you can do that. One is if you are on Twitter, you can tweet to us. You can use this hashtag here, Shriver Hangout. We're at Shriver Center. And you can go ahead and try that out now. You can also email me during the course of the conversation, and I've got my email address there as well, amandamoore@povertylaw.org. I have various little devices over here with these screens popped up, so I'll be monitoring those while we talk. But without any further ado, we'll pass over all those housekeeping matters and get to the reason that you're here, and that's to talk about due process in a modernized public benefits system. I want to start with sort of the big picture before we get into a few more of the specifics. Gina, let's start with you. What do we mean when we talk about a modernized public benefits system, and are we talking about any benefits in particular?
Well, hi, Amanda. Well, when we talk about a modernized system, we're really talking about a range of strategies that states have been adopting over the past decade or so to try to streamline and improve the administration of their public benefit systems. So these are strategies that are likely familiar to most of the people who are participating today. They include such things as very sophisticated automated eligibility systems to determine eligibility and manage cases. There are web-based systems for submitting applications, perhaps uploading documents, receiving client notices, reporting changes. Call centers play a big role in many of these systems, with individuals using call centers perhaps to conduct interviews, resolve eligibility questions, and engage in the regular communications with their workers that would have typically taken place in the offices. Digitalized information is another common element. Offices wanting to go paperless and getting digitalized information from the clients and associating it with their files. Business process reengineering is another key component. We see a real departure from the traditional model of bricks and mortar offices where individuals go, they're an assigned caseworker, they meet with their caseworker and have all their dealings with the caseworker. Instead, with this new model, workers have tasks that they do. So an individual doesn't have an assigned caseworker to resolve cases with, and it's a much more remote process. Obviously, some of these systems can get unbalanced and raise lots of issues for individuals that threaten their access to benefits and their ability to maintain benefits. So in a nutshell, that's what a modernized system refers to as we define it. And we see these systems coming into play in the programs that we typically deal with, which are food stamps, Medicaid, and cash assistance programs. But I think they pervade a range of government benefit programs, including, for example, unemployment insurance benefits. And to the extent that the people who are on this call today have experiences in other program areas, and these are common issues, I think we have a unique opportunity to explore some of the concerns and the strategies and solutions to improve access for people, no matter what the benefit program is.
And Greg, so that lays out what we're dealing with. It sounds good in an ideal situation, but Greg, what problems have either recipients of benefits or applicants for benefits run into in these modernized systems?
Well, advocates around the country are seeing these clients who are adversely affected by modernized public benefit systems that are in fact dysfunctional. This is increasingly resulting in systemic failures that prevent eligible clients from accessing and maintaining their eligibility for benefits. There are a number of examples, and I'm sure the folks around the country are seeing these. First off is auto closures. Computer systems may be programmed to terminate cases automatically if the worker hasn't entered the appropriate instruction. The worker's failure to timely act on a submitted application or recertification, including entering properly submitted verification documents into the system, results in cases being routinely and automatically closed without any opportunity for an individualized determination. Faulty systems and procedures for document imaging and scanning into digital databases, which many states are increasingly going to, as Gina mentioned. If the submitted documents aren't matched properly to a case, through proper barcoding, for example, then they're essentially lost and they may not be retrievable. This results in benefits denials, terminations, and delays. The agency notifies the client that the necessary documentation was never actually received when it was properly submitted by the client. The agency may attempt to do manual workarounds to get access to these documents, but these frequently are not successful attempts. And Gina mentioned call centers. With many states going to regional or statewide call centers, a number of problems are typically resulting. High demand and inadequately staffed call centers can lead to overload of the system. This results in lengthy waits for clients trying to get through, sometimes up to an hour, sometimes more. Large numbers of abandoned calls and dropout rates where clients give up, and other access issues. This prevents clients from being able to deal with eligibility problems by talking to a worker at the call center, completing mandatory eligibility interviews, and all sorts of other problems that lead to interruptions in service. To the extent that programs around the country are going to websites for online application and recertification, inaccessible websites as well as call centers present unique access problems, both for people who have LEP issues or literacy issues, and also very severe access problems for clients with disabilities. For example, folks who have sensory disabilities, folks who are blind or deaf. If you attempt to interact with an interactive voice response system in a call center and you're deaf, you have to work through a third-party relay operator that presents all sorts of problems. If you're blind, trying to access a website for eligibility information or to maintain your eligibility, if the website's not accessible to, for example, a screen reader that can interpret text into audio format for the person who's blind, that's a severe problem. All of this leads, as we know, to churn. Clients who experience procedural denials and terminations resulting from these types of systemic failures are frequently forced to reapply and they'll lose benefits in the interim. That's just the tip of the iceberg of some basic problems that are being encountered around the country, and I'm sure the advocates on the chat are very well versed in these sorts of problems because they're coming in through their doors.
Mhm. Right, and I want to remind our viewers that you can send us, your experiences, or if you have a question, our guests would love to hear it. You can send that through the Q&A box on the Google Hangout, which you can find if you hover over the left side of your screen, or you can send an email to me, Amanda Moore at povertylaw.org with your question, or you can tweet to us. All sorts of ways you can let us hear from you. And I want to remind our viewers that we are recording this conversation and we'll post it, so it will be accessible later. Also, our guests have written a fantastic article that goes into more detail about what we're talking about today. That article is called How to Protect Clients Receiving Public Benefits When Modernized Systems Fail, Apply Traditional Due Process in New Contexts. And that's our Clearinghouse article for this month. You can find that on the Clearinghouse community, which is at povertylaw.org/clearinghouse, and you can read that article. Within that article is a wonderful piece that's a real practical example, and Kristen in Philadelphia wrote that along with her colleague Amy Hirsch about the work that they did specifically in Philadelphia to improve this system, their modernized benefit system. And we will get to Kristen very soon to hear more about her experience. Every person who registered for the Hangout will get a follow-up email. You'll get a link to that article. You'll get a link to the recording of this Hangout as well. So I want to remind you, you will have access to a little more detail of this if you take a look at their article. All right, so Gina and Greg, you've laid out the picture for us. Now let's talk about due process. That's it seems sort of clear, but if you could put into concrete terms for us, what are the due process problems with these types of barriers and hurdles that Greg just described?
The due process problems fall typically into issues of fundamental fairness, fundamental obligation of an administrative agency to treat both applicants and recipients fairly to ensure that they have the access to the information needed to process an application, to retain their eligibility for benefits, and that workers apply complex rules the same in similar circumstances. And what underlies a lot of the problems we see here is that individuals do not know what the expectations are that are being imposed on them when they seek to apply or retain their benefits. The workers frequently don't know because as the systems are being changed, workers are often equally confused about what the obligations are. And to us, this is a revival of a lot of the very basic fundamental due process principles that were very much informing a lot of the public benefits, food stamp, Medicaid, cash assistance work in the late 60s, early 70s, and into the beginning of the 80s, where basically courts were holding that governmental agencies had a fundamental obligation to inform persons applying for public assistance, whatever the form of assistance might be, of the terms and conditions of eligibility, that those terms and conditions of eligibility be uniform from person to person to person, that the person have a right to submit to the system, have their application considered fairly, that the workers operate pursuant to clear, articulable, and discoverable guidelines, and that at the end of the day, people have an opportunity, if they're going to be terminated, to know the reasons for the termination and have an opportunity to challenge those terminations through the presentation of evidence. This is due process more fundamentally wrapped up in how a governmental agency interacts with the public, and is not the traditional notion of due process that many of us have used in our practice, where we look at whether or not a notice is adequate or whether or not people have been given the notice in the first place. This is much more fundamentally about how people are treated. And part of the reason this sort of notion of fundamental fairness is so critical is because increasingly, and most of the advocates on this call will know this, that it is harder and harder to find a claim that you can go into court and file a successful lawsuit to enforce a federal statute or to enforce a federal regulation. And these are issues that may go beyond the simple scope of a regulation or beyond the simple scope of a statute, and require looking at an entire way the system operates interacts.
And I would just like to add to that that we typically think of procedural due process as involving notice and the opportunity for a hearing on a denial or before benefits are terminated. But we're talking about something broader here, because if you've been denied an opportunity to participate or excluded for procedural reasons, you know, a hearing can have limited utility. Being able to prove that you in fact submitted documents that were lost by the system, or that you were available for the interview by telephone, but the worker didn't call you or you couldn't get through. Those are very difficult issues to address in a fair hearing. And so by trying to look again at this older due process case law and see what it says to us today about these systemic issues that we're seeing, we think can help provoke a lot of dialogue and perhaps shape advocacy as we go forward.
And that for us is really the critical word here, this notion of an opportunity to do systemic advocacy in a way that affects more than just the individual applicant or recipient, but ensures that the interaction between the agency and the communities that the agency is charged with serving is fundamentally fair.
Well, I know what often our viewers and readers want is something really practical. Can you give us, you know, a sort of step-by-step roadmap how we bring these types of claims? Is that something that you can do, the way that the situation that you're describing? Mark, is that, can you lay out a roadmap for us?
Yeah, I wish I could say to the people on this Hangout that they should look for volume 2 of our article, which will be coming out next month. But practically, the difficulty is there really is no uniform roadmap, because what all of the scenarios we describe have in common is a fundamental unfairness. But as described so well by Greg and Gina, what they also have in common is they're all very different in the way that they're fundamentally unfair. It may be about interaction of phone systems, it may be about lost documents, it may be about misinformed workers, it may be about a failure to inform the public. There are a couple of things, though, that we do think people need to do in order to be thinking about whether or not there is a systemic due process challenge that might be available to them. And I would say the first and foremost, and I'm sure that Kristen and her crew did a lot of this as they were leading up, is you need to really understand the reason for the problems that the clients are experiencing. Factual development, even more so than a traditional public benefits case, is critical. You need to not only understand why people are being harmed, but what the operations are that cause the harm on the part of the agency. And you have to be able to give some thought to the kinds of fixes that might be likely to make it better. So are we talking about a system of lost documents, a system of lost phone calls, a failure of training? All of those are important issues, and factual development is really, really critical. The second thing that we think is critical is to think outside of traditional advocacy boxes. It is not, and Kristen's work is a great example of this. It's not simply, can we file a lawsuit? Can we do an administrative hearing? The tools here can be many and varied. Certainly litigation is a piece of that, but there can be policy advocacy. There can be attempts to bring in key actors. There can be attempts to work with federal oversight agencies, potentially other state agencies in a particular state. The tools are many. One of the things that we are prepared to do is to work with any state or any advocate that has an interest in looking at issues that are going on in their state, and to advise, partner, do whatever makes sense under the circumstances. But the tools are really going to vary depending upon the circumstances. The identification of which tool is most appropriate to which problem is part of the really hard work in this after the facts have been developed.
Well, you mentioned Kristen's work in Philadelphia. That's a good chance to turn to you, Kristen. You can give us a practical example of a situation where you were able to take steps and make some real improvement. Can you tell us about some of the specific strategies that you and your colleagues at Community Legal Services used in Philadelphia?
Sure. So what we were seeing in Philadelphia is very much what Greg and Gina and Mark have been talking about. You know, the systems were broken. We had clients that were flooding our offices and just could not navigate the basic application process or the reapplication process, and our intake was through the roof. We do a very high volume, like a lot of legal services programs do, a very high volume public benefits practice. And we had the sense that things were really bad. And one of the things we started doing was capturing stories and story banking. But I think that we find internally that the really egregious stories stick out for us, but it doesn't necessarily capture the full trends. And we also find, because we receive funding from the state, but we also sue the state, we have a process in place where we have to give the state an advance notice before we proceed with litigation, and potentially engage in good faith negotiations before we proceed to a lawsuit. And so when we started that process, I think we found, as we often do in those kinds of negotiations, that we're asked for specific examples, and then maybe those are fixed, or we're told, oh, well, those are not representative of what's really happening. And we were finding that just that was really the state wasn't really eager to give us data showing us how bad the problems were, even through our right to know process. What we could get was limited. So what we did was we took our case management system, Legal Server, and we built 9 questions into it that really captured a lot of these issues. So every client that came in for intake, the person who did the intake asked a client with a public benefits problem, are you here because your paperwork was lost? Are you here because you got cut off because of paperwork, which is sometimes a different issue? Are you here because you couldn't get through on the telephone? And really ran through what to us were the most endemic problems in Philadelphia. And what we were able to do is we were able to sort those by our district offices, because there's 11 district offices in Philadelphia, see where the problems were, see where the trends were over time, and also really paint a picture for our state Medicaid and SNAP and TANF agency that these problems were not just a few cases that maybe fell through the cracks. This was really a significant problem, and that there were trends that were showing that things were getting worse even as we were having these negotiations. And I think that really succeeded in changing the tenor of the conversation with the state. I think it also has been really helpful in the aftermath. We had some very happy successes in that, our call center flow of calls was changed in a beneficial way to our clients. There were some computer programming changes, some changes to the SNAP interview process, some data that was compiled and shared with us, regular monitoring meetings, and all of those things. This data has really allowed us to make sure that we're going on the right track, identify problematic offices, and it's helpful in our other advocacy as well. For example, FNS sent us a questionnaire about a historically problematic district office in Philadelphia, and we're able to look at that office relative to other offices, even now, several years after these negotiations, and see if things are improving there when that office was really the most problematic several years ago.
Well, that was one thing that really struck me when I read your piece of the article, was just the great use of data that you implemented there. And I also like hearing about the changes to your intake system. It's almost like you're implementing your own modernized system to combat the bad one or the faulty one. So those are really great practical examples. We've had a couple of comments come in. Before we get to those, though, I want to make sure to ask Gina and Mark and Greg. I know, obviously we've had this huge response to this. A lot of people are working on these issues. If they want to collaborate or share strategies, talk with people like Kristen who have been through this and come out on the other side with something better to show for it, what can they do?
So what we would like to do, and one of the goals in putting out this article, was to provoke discussion and communication among people who are working on these issues. We suspect that there is a lot to share in terms of thinking, strategies, best practices, results, obstacles, various opportunities, and I think all of our advocacy could be enriched by sharing that. So we'd love to hear from people who are engaged in this work, because we don't want to just get stuck on all of the problems that we agree on. We want to figure out and hear what people are doing on a systematic basis and where they see the opportunities. So our suggestion in the article is that those of you who are interested in working on this issue, email one of us. Our email addresses are in the article, and give us your name and your program information so that we know where you are. if you have any observations about what kind of communication and coordination you would find useful and what programs you're working on, that would be a good place to start. And any suggestions for, how we could proceed. And we'd love to hear from all of you and then get back to the group and move forward from there, making something as useful to a group of busy people as we can possibly do.
And let me just stress, part of our goal here is to make this as interactive as possible. So at some point in the future, depending upon what you've identified as your needs, we could be looking at conference calls, further types of hangouts, whether it's sponsored by Shriver or not, but opportunities for an interactive communication, share templates, opportunities for shared experiences, because we do believe that, as Kristen's example highlights, that learning from each other is going to be the best way to move forward. And we're happy to facilitate that process moving forward.
And I'll remind our viewers that you will receive an email either later this week or early next week as a follow-up to this event. Everyone who registered will receive the email. It will contain a link to the article that our guests wrote and a link to this Hangout, and we'll also be sure to include all of my guests' contact information, so you can find those emails very easily and get in touch with them. We do have one question and one comment, both from Indiana, interestingly. Valentino wrote in to say he's seen it all. So I think probably a lot of viewers are having the same thought. And then we had a question from Amanda, and it's a little specific, so it may be something that's best dealt with in one of these follow-ups. Maybe you all could contact her directly, or she could get in touch with a group that may be forming. But I'll go ahead and ask it in case you have some general points to share that would be relevant for others. She's talking about a Medicaid waiver system in Indiana. There are 3 managed care entities, a state, and a data exchange between them. If there's a breakdown in the data exchange, insurance is cut off or delayed. They're dealing with this on a case-by-case basis, and it's becoming overwhelming. They usually resolve the problem after, attorney, caseworker, client hours on the telephone, and she wants to know if there's a better way. So I think we may have given you, Amanda, a few ideas. Kristen had some ideas to look at this from a more systemic view and how to work on that. Do any of you have other suggestions for Amanda or people facing situations similar to theirs?
I think in Amanda's situation, we would ultimately need to know a lot more to be able to comment specifically. I will say more generally, one of the challenges in the modernized system in post-1996 welfare reform is that with the devolution of various benefit programs to different agencies, Medicaid, now through the Affordable Care Act, you often have it being split among multiple state agencies, and getting the state agencies to talk together, to work together. They sometimes have different computer systems. We saw that in Indiana. We're seeing that in Colorado. We see that in New York, and a number of states in which we work. And the critical part is being able to figure out how to get the 2 state or 3 state agencies together, along with the State Office of Information and Technology, so that everybody's on the same page, and to get somebody who is a sufficient level of authority to take ownership of the fix, because government agencies do like to pass the buck, as you all know. So getting that person who can say this is what the fix needs to be is critical. And as to Amanda's more specific question, we'd love to have a conversation offline.
And of course, the landscape, as we all know, frequently includes private contractors now. With the increasing privatization of all of these public benefit services, you've got to deal with vendors, contracts, and all of the ramifications of that, whether or not they're adequately monitored, whether or not the contracts themselves are adequate, and whether implementation is adequate.
And of course, Indiana has a nice track record of having brought on vendors and contractors and then discovering that relationship doesn't work. So we're not surprised that problems are being experienced.
Well, I should add that for the next 2 months, our clearinghouse articles are going to focus on these types of due process and public benefits articles. Greg, you mentioned the contractors. Our article for March comes to us from Jane Perkins at the National Health Law Program, and she's going to write about those types of contracts and ascertainable standards for those. So that's coming up. And also next month, our clearinghouse article is going to be on due process and notice, in particular state notices, and that comes to us from Ty Jones at the Center on Budget and Policy Priorities and Sovereign Hager at the New Mexico Center on Law and Poverty. which is actually a good segue to let me invite you to join us for next month's Hangout. Ty Jones and Sovereign Hager will be my guests, so this will be another due process Hangout. So if this has been something that's relevant to you and interesting, I encourage you to join us again next month. That Hangout will be on Wednesday, February 10th, and will be the same time as the Hangout today. So that's 1 o'clock Eastern, 10 Central. Oh, no, sorry. 1 o'clock Eastern, noon Central, 11 Mountain, and 10 Pacific. I work my way across the country. So I do hope that you will be able to join us. There will be a link to register for that Hangout in that follow-up email that you will receive. I also want to thank Susan Sternberg, who's doing some great tweets promoting your work and encouraging people to get in touch with you. So thanks, Susan. I want to thank all of you for joining us today. Our half hour has expired quickly, as it always does. I want to thank my 4 guests. So thanks to Mark, Gina, and Greg in New York.
Thank
Thank
you.
you.
Thank you.
And thank you to Kristen in Philadelphia.
Thank you.
And thanks to all of you, and I do hope that you'll join us next month while we continue this conversation on public benefits and due process. Thanks.
Thank you.
Thanks.